case before us. It's case number 129466 from Leavenworth County, City of Leavenworth, Kansas, appellee versus CoreCivic Incorporated appellant and Misty, Linn, Mackey defendant. Would the parties please state their appearances?
May it please the court, Sarah Beverly on behalf of CoreCivic. Your Honor, I would request 3 minutes for rebuttal.
3 minutes are granted.
May it please the court, Joe Hatley from the City of Leavenworth. City Attorney David Waters is also present.
Thank you very much. Mr. Feverly, or Ms. Feverly, you may proceed.
May it please the court, Sarah Beverly on behalf of CoreCivic. Just this year, this court in Harper said the single most important prerequisite for the issuance of a temporary injunction was irreparable harm. The district court's analysis of irreparable harm here falls short of this important prerequisite. It analyzed irreparable harm in a single sentence in its order. The court can reverse on this basis alone. But even if this single sentence analysis could somehow be construed to meet the requirement for irreparable harm, this finding violates exactly what this court said can constitute irreparable harm in Harper. The district court's conclusion rests on the presumption that the city is right on the merits of the lawsuit. Specifically, the development regulations require CoreCivic to obtain a permit, and CoreCivic's failure to do so violates the law. This simply cannot be squared with Harper. The district court improperly merged the analysis on the elements of likelihood of success and irreparable harm. Harper expressly teaches that this is not allowed. Again, this court can reverse on that basis alone. Finally, the district court's order can be reversed because the finding on irreparable harm is not supported by the extraordinary evidence required in Harper. The court can end its analysis at this point.
Counsel, let's talk about irreparable harm a little bit because I'm familiar with the facts in Harper. And in that instance, the argument was that the government's argument is essentially there is irreparable harm because of the fact that the Attorney General's office had said that there was a violation of the statute in that instance, and there wasn't any other evidence. It strikes me that here it's a little different because it's not just, is there a violation of the ordinance, but the outcome would be that this facility would be operational. And that's a very real difference between the two. Would you agree?
Your Honor, I don't think that Harper is confined in any way to. Your Honor, I don't think that the findings or the analysis in Harper should apply any differently in the zoning context. There's not any sort of lessened burden for irreparable harm. And what Harper says is there must be some additional tangible consequence beyond the mere violation of the statute.
And is the operation of a facility not a tangible difference?
Well, Your Honor, it's just speculative at that point. And if you look at some of the case law that's analyzes irreparable harm in the zoning context, and we have several cited in our brief, but even the city's own case law confirms that irreparable harm requires this additional tangible consequence. They cited a case, Board of County Commissioners of Leavenworth County versus Whitson. And in that case, the court was analyzing a group home for sex offenders, and the court looked at additional evidence like the potential for reoffending and the danger to the community, and that was all in the evidence in the record. And here we don't have that same evidence in the record. Everything that the city cited to is all past harms, and the Kansas Supreme Court is clear that past harms cannot constitute irreparable harm. So there is no additional tangible consequence. And in your example of kind of what what could be irreparable harm in the zoning context, you can find these additional tangible consequences, like in the case that I just cited, where there was indeed evidence in the record of these additional harms that can be found even in cases in the zoning context. But
In the absence of an injunction here, what would your client have done? Would your client have operated a facility in the city of Leavenworth? I mean, it strikes me that the difference is, on the one hand, in Harper, we're talking about potentially theoretical harms, and that's what the court found, without any evidence. And here, your client was seeking to actually tangibly operate a facility, and it was either denied a permit or that permit was rescinded. But regardless, that's a very different situation when there is intended action.
I understand the court's concern. However, again, if you look at the analysis of some of these other zoning cases, there is, even in, the absence of the facility or the entity actually operating, the party was able to put forward some evidence of the tangible harms, and we just don't have that here in this record.
Counsel, let me ask you a question. As I understand here, this has been a non-conforming use for some time. Initially, because it was grandfathered in, correct? There's never been a permit for this facility to work. It's always been grandfathered, and then you discontinued the use of it. So all of a sudden, because you want to reopen the facility, it becomes a conforming use? It seems to me that the standard is it was non-conforming to begin with. It's still non-conforming until you get a permit, correct? Or is that too simplistic?
I just want to clarify a couple points. So CoreCivic never had a special use permit.
It was always grandfathered in, right?
Instead, under the development regulations, I believe the relevant regulation is 1.05E2. They were grandfathered in as a lawful conforming use and a special existing use.
Mm-hmm.
So they were not.
How long was that good for? Until you quit using it?
So CoreCivic never abandoned or discontinued its use of the facility.
Stopped using it, didn't you? Didn't have any prisoners, did you?
Under Kansas law, under Vickers and union quarries, it's very clear that mere cessation of use does not amount to a discontinuance or abandonment. Instead, abandonment is defined under Kansas law as both an intent to abandon the use and an intent to abandon the use and apologies. I want to make sure that we have the relevant standard. And CoreCivic, on the record below, there is no indication that CoreCivic ever intended to abandon its use. Instead, the record below is that CoreCivic, at the time that the rescission in the resolution was made, CoreCivic had an existing contract for detainees. They were marketing the property throughout the time for detainment services. They had employees that were working at the facility. So the mere cessation of actual detainees at the facility does not amount to abandonment under Kansas law.
And how long was that cessation for? Does the record show?
I don't believe that the record shows that amount of time.
Did the district court make a finding on that?
I don't believe there is a date finding of how long.
Did the district court make an abandonment finding? Because that's a question of fact, is it not?
I believe that there was a finding related to abandonment, but
And what's our standard in light of the fact that the district court has made that factual finding that CoreCivic abandoned this use? How do we review that?
a factual finding would be reviewed under abuse of discretion, but a legal finding would be made, would be reviewed de novo.
And would you agree that abandonment, whether someone has abandoned and met that standard, is a factual finding that the district court needs to make based on the evidence presented?
I don't know off the top of my head legally whether it would be a fully factual finding. I have some suspicion that it is maybe a quasi-factual, quasi-legal finding.
One of those many mixed questions of fact and law that we have.
One of those many, yes. I do not, off the top of my head, standing here, have the a relevant standard for whether this would indeed be a fully factual question. And I also do not know whether the district court's finding is wholly premised on or is made a finding related to abandonment. But again, still to the point, even if the court below was correct on the abandonment finding, which CoreCivic disagrees with, you still have the other factors that have to be met. And as we previously discussed, irreparable harm under Harper is simply not met, particularly on the one sentence finding in paragraph 5 of the order below. And for that reason, this court doesn't even need to wade into the weeds of this abandonment finding or any of the factual findings below.
What if we disagree with you and we actually do need to get into those findings? Is there a reason why the district court's decision was incorrect? What's the strongest reason in your view?
The strongest reason that the district court's order was incorrect is on the irreparable harm finding.
But putting that question aside, I'm looking at those other factors that we consider when we have a temporary injunction.
Yeah.
Putting aside irreparable harm, what is your strongest argument for reversal?
I see I'm coming to the end of my time. May I
Please
respond? I think that if you do indeed look at the substantial likelihood of success on the merits, under Kansas law, there is simply not a record below that CoreCivic abandoned the facility within the meaning of Kansas law. And in addition, the district court was very hung up on 12760 and whether there was any sort of failure to exhaust administrative remedies. There is no record below that this was a final decision within the meaning of 12760 that was appealable in any way. And so for those reasons, I think the district court's order must be reversed and the temporary injunction must be dissolved.
Thank you. Any other questions from the?
Yeah, I have one question.
Sure.
Your client's goal is to begin reusing this facility as a detention center with or without a permit. Is that right? You want to start reusing the facility as a detention center?
Yes, my client does want to use the facility as a jail or prison as it has for many years.
And if your client accomplishes that with a permit, that makes this case meaningless. Isn't that correct?
No, and I'll take issues with that for two reasons. The permitting process is, there's a lot of variability in the permitting process. There's no really secure timeline. There's no guarantee that the permit is going to be granted. There's no guarantee on what conditions will be with the permit.
You see what I'm getting at here?
Yeah, but in addition, and we cited to this statute in our brief, under KSA 60905B, to the extent this court finds that this temporary injunction was improvidently granted, CoreCivic is entitled to fees and damages associated with the improper grant of the temporary injunction. So regardless of whether there's a permit, that is still a live consideration for this court.
Okay.
Any other questions? Thank you. Counsel?
May it please the court. CoreCivic initially applied for a special use permit and then it withdrew that application midstream, taking the position that it no longer needed one, even though the zoning regulation required at that point a special use permit to operate a jail or prison within the city. KSA 12-761 explicitly authorizes injunctive relief under these circumstances even before a violation has occurred, when there's a threatened violation. That's what we were dealing with here. And that was the basis for the district court's injunction.
You still have to prove irreparable harm, correct? Or
When
an approximation of it?
one could debate that, I think, under 12-761, but I'll answer the question. The city did.
All right.
The city
Tell me
did.
how.
There were two affidavits that the city submitted. One was from the police chief outlining how when CoreCivic was operating this facility 3 years before, it had been vacant for 3 years, they were unable to investigate crimes. They were thwarted in their attempts to investigate crimes. CoreCivic was at times having inmates clean up crime scenes before the police could get there to investigate them. They were interfering with the police ability to interview witnesses. And then we also had an affidavit from the supervisor of the wastewater division about the problems that CoreCivic was causing downstream because they didn't have a grinder pump. A grinder pump's basically a garbage disposal on steroids. And if something solid goes into your sewage system, it grinds it up so that they can then be processed. So
These are all major concerns for land use.
they're very major concerns for land use. And to get to the nub of the problem, CoreCivic provided no evidence through affidavit or otherwise that it had done anything or was going to do anything to keep those problems from happening again.
But
It didn't seem that the trial court elaborated much on this.
I don't believe the order elaborated on it very deeply, but the court can obviously affirm the decision if there's evidence in the record to support it, irrespective of whether the trial court specifically called that out in the order.
counsel made an assertion that past harms cannot constitute irreparable harm. So what you just cited, does that rub up against what you just cited as your basis for irreparable harm?
I think it does support that because, like I said, if CoreCivic had come in with affidavits, here are the things that we've done to keep these problems from happening again. We've bought a grinder pump. We've put it in during this time it's been vacant. We can promise you're not going to have those problems again. This would have been a tougher case for us, but they provided no evidence whatsoever to respond to that.
Are those, what you just cited, are those issues that go to irreparable harm? Or are they kind of meritorious bases for why it was reasonable to rescind the permit?
A little bit of both. I think
So does that overlap or are those separate?
it could overlap because, and this gets to the question, how far can you go on a 12-761 injunction? What you have to show irreparable harm. Our position is if you're dealing with the zoning violation and you continue to tolerate even de minimis violations, eventually at some point you have a big problem. So maybe irreparable harm would be relaxed there, but here we actually proved it through the evidence that we provided.
Counsel, I'm intrigued by this idea. The way I read this record is they never have had a permit. They've never had a special use permit. It was grandfathered in to begin with. And then they quit using it as a facility, even though it's still there. So do you re-grandfather something in once you
No.
quit using it? What does the law say on that?
Well, the way the development regulations, which is the zoning ordinance, reads, effectively they were deemed to have a special use permit when they were grandfathered, even though they didn't have the piece of paper.
By the ordinance or administratively by the city?
By the ordinance. They were grandfathered
All
in,
right.
so they're deemed to have a permit whether they actually have one or not. That is then what allows the city commission to administratively rescind that after they stopped using it as a detention facility for more than 12 months. And it was actually for 3 years. They stopped using it in that manner in very end of 21, 22, beginning of 22, after the Biden administration issued an executive order prohibiting the Department of Justice from contracting with private prison operators. And what's significant here is the not putting more people in there after that was a choice, because the executive order only applied to DOJ. They could have gone and contracted with ICE. There was nothing to stop them from doing that. They could have contracted with the state of Kansas to operate this as a minimum or medium security facility. There were a lot of things they could have done with this property. Instead, they let it sit vacant, and all they did basically was keep the lights on.
The second item that strikes me in this is a temporary injunction.
Yes.
Where is this lawsuit going from here?
Well, follow up.
Depending on how we rule, of course, I understand that.
We're now going outside the record, but I think it's out there in the public domain. CoreCivic has applied for a permit, and they're scheduled. They had Planning Commission hearing last week, I believe. Planning Commission recommended approval. City Commission takes it up now. The final hearing is March 10. And our feeling is if the City Commission issues that permit, this case becomes moot. So that's, to answer your question, that's where this is going.
Thank you, Council, because I thought maybe that might be what your
Right.
answer was,
And-
but I wanted to hear it.
And if the City Commission denies that permit, there may be another lawsuit on a different basis challenging it under Golden.
Well,
Yes.
we're open year round.
Unfortunately, we are too.
Council, in light of that procedural posture and the fact that there are these other administrative proceedings going on, we don't tend to issue rulings and opinions just because we find issues interesting.
No.
Right? There has to be a concrete matter before us. It feels like we're in a strange position here.
I thought about that a little. I don't think the case is moot at this particular moment because they don't have a permit. But if they get a permit on March 10, it does become moot. So
Council asserted that they would still have a money damage claim. But do you have a response to that?
well, I think they would have effectively mooted it at that point, and they've not. I'd have to go back and look at their petition, or actually, they've not counterclaimed for damages.
There are damages for, I guess, the improper granting of the temporary injunction.
Right, which would require this court to reverse that temporary injunction because that's the only basis upon which there could be a wrongful injunction claim.
Which is why they're saying it wouldn't be moot.
Yeah, I suppose that might be an argument, but right now we're just here on temporary injunction, and we believe we proved the necessity for one. One point I wanted to make too under irreparable harm is that and we touched on this in the brief, is the inadequacy of legal remedy, because I don't know how you calculate damages based on the police inability to investigate crimes. There are people who get hurt by that. There are victims in the facility who are hurt by that. And that is prototypically the sort of thing that you can't even bring an expert in and quantify. And it's the inadequacy of legal remedy that creates irreparable harm. We touched on this in the brief that maybe the 5 factors from Harper really ought to be 4, because irreparable harm is the inability to calculate damages. And that's what we have here. It's simply something that can't be calculated. And that's why there was irreparable harm. We also made the point, as actually in our motion, that once detainees got into this facility, it would be much more difficult for the city to do anything about that. Because it would require a state court judge telling CoreCivic, you've got to move people out. And their position has been, well, once ICE tells us that somebody's in, we don't have any control over where they go. And I think that concern has been somewhat prescient because, as we've seen, even federal judges have had difficulty getting ICE detainees out. So you can imagine the difficulty that a state court judge would have in telling a contractor to move people out when you now have the federal government in there with a concrete interest. So that was another reason why temporary injunction was appropriate here. When I want to shift over to the success on the merits, because the basis that the district court largely relied upon was the fact that CoreCivic had not filed a timely 12-760 suit challenging the legality or the reasonableness of the city commission's resolution. That resolution was adopted on March 25, It was delivered to CoreCivic a couple of days later. And by the time of the hearing, which was June 4, they still had not filed anything. And that was what the district court really hung its hat on. But that was an appropriate thing for the district court to do for the reasons we cited in the brief. The district court, when you're faced with a temporary injunction, you're having to predict how this case is going to turn out when you're assessing likelihood of success on the merits. This was not an affirmative defense. Rather, this would have been an affirmative defense the city would raise to a hypothetical claim that CoreCivic hadn't even brought yet.
The parties have alluded to the fact that there is a separate lawsuit ongoing on that issue. Is that accurate?
It's been filed, but not prosecuted. It's not been, to my knowledge, I don't even think the city's been served on that one.
This is a difficult case because it feels like there are all of these slippery parts that are not part of the matter before us. There's a separate lawsuit, there are ongoing administrative proceedings. It's
CoreCivic filed, CoreCivic filed a suit in federal court seeking injunctive relief based on some supremacy clause. And the district court there dismissed the suit, denied their preliminary injunction motion. So yes, this case has been active on a number of fronts over a relatively short period of time. But we're here today on this temporary injunction, which the district court said was warranted because of the fact they had not brought a timely challenge, raising a lot of the arguments they came in and raised. But I also believe that even if we get beyond that procedural reason, substantively, it was proper. The city would be likely to succeed on the merits because they needed to have a permit to operate. As we've alluded to, they vacated the space, at least as far as detainees are concerned, for 3 years. And it sat there. They kept the lights on, they kept the floors mopped and so forth.
as I read the development code, there's a discussion about legally non-conforming or a non-conforming legal use and a special use.
Right.
That code provision doesn't say that is an implied special use permit. It seems as though we're discussing it as though it is. And then there's a separate code provision that talks about rescinding a special use permit. Can you help me with the logical jump between those two provisions?
Sure. I think those are separate. The first thing you were talking about, Your Honor, is in response to one of Judge Hill's questions, they were deemed to have a special use permit because of the grandfather part of the development regulations, because we can't come in and.
And the statute doesn't, or the ordinance doesn't specifically say that, but we just make that logical leap.
I think it effectively it says you're treated as if you have a special use permit. It may not have that exact language, but that's the position. And I think the word deemed might even be in there. I don't recall off the top of my head, but that was the point we made. But then if they stop using it in the manner that would ordinarily require a special use permit, which is holding people, and that continues for 12 months, the city commission can administratively rescind that special use permit, which they're deemed to have. There's a separate provision on non-conforming uses that says if you stop your non-conforming use for 24 months, it can be terminated. So there are really three things scattered around the code, but that's how they play with one another. Now, I want to touch very briefly on this abandonment argument, though, because their position is, even though they may not have had detainees in there for 12 months, 3 years actually, we still had to prove an intent to abandon. And that really doesn't make sense. We cited a bunch of cases, Kansas and other states, where if you have this temporal limit on non-use, you no longer have to prove intent to abandon. And there's a reason it creates a bright line test. And here's the point I really want to leave with on this. If you have a temporal limit like that and you still have to find an intent to abandon, the temporal limits become meaningless. Why have a temporal limitation if the person can come in and say, oh no, I never intended to abandon that? That really violates accepted canons of statutory construction because you're making that temporal limitation meaningless in the context of the facts of a case like this.
Does it then act as a presumption?
It's an irrebuttable presumption, Your Honor, is our view. Because they clearly were not housing detainees for a 3-year period. And that's the housing of detainees that triggers the permit requirement. My time is up. Are there
Further
other
questions from the panel?
All right,
Thank you. Council, you've reserved 3 minutes for rebuttal.
As Judge Warner so aptly put it, this is a somewhat slippery case. There's a lot of moving parts. So I want to recenter our focus on what we're looking at here today, which is whether or not the district court properly granted a temporary injunction. And that requires, as this court knows, extraordinary evidence on all 5 factors. That simply is not present here. I want to go through 3 points quickly. First, I want to talk about the irreparable harm analysis again. Mr. Hatley briefly spoke about 12761 and kind of intimated that there's some sort of lessened burden for irreparable harm because of this authorizing statute. And I want to dispel any sort of analysis that would be correct. In our reply brief, we cited 2 Kansas statutes that similarly authorize injunctive relief. And in those 2 statutes, the legislature is explicit when it says that it wants to eliminate the irreparable harm finding. And obviously, if you look at 12761, that language doesn't exist. And again, as I alluded to when I first got up, when you look at these temporary injunction orders on appeal, the analysis from the court still analyzes irreparable harm separately from the zoning violation itself. Mr. Hatley also mentioned on several occasions that CoreCivic needed to submit some sort of affidavit to contradict the past harms that the city alleged had happened. And that really flips the burden on its head. The city has the burden of extraordinary evidence. My second point is there was some discussion about CoreCivic not having detainees for a certain period. The standard for abandonment in Kansas is very clear. Mere cessation is not enough. There has to be an intent to abandon.
What about the temporal limit that council mentioned? You've got 1 year.
The temporal limitation still doesn't eliminate this intent to abandon. I believe it was the Vickers case that discussed the combination of the 2, and where within Vickers in the regulations, it said that there was no need to show intent to abandon. So the city could have written that into their code. That's an option, but that's not what we have here. Finally, I wanted to talk about whether or not this case becomes moot in some way again. May I just finish?
Go ahead.
Like I discussed earlier, there's nothing guaranteed in the permitting process at this point. And CoreCivic would appreciate a ruling as to this extraordinary remedy that the district court below entered against it. Thank you.
Thank you very much. I want to thank all counsel for your arguments in this case, both written and oral. The court will take this matter under advisement, issue a written opinion just as soon as we're able.